Welcome everyone to the Judiciary Committee hearing this Friday morning. Our 9:45 agenda is up first. If we have a catastrophic failure on the Zoom side, we'll try again on Tuesday, March 19 at 9:31 a.m. in this room 016. You have a 2-minute time limit on testimony for both Zoom and in person, so you can stop when the buzzer goes off. First up today is HB 1805. This allows for the interest earned on payments under protest in the litigated claims fund to be paid in non-taxation cases if the claimant prevails, establishes a procedure for the disposition of monies and refiling of petitions when a payment under protest suit is filed prematurely. First up on HB 1805 is Director Suganuma for the Department of Taxation. Good morning.
Good morning, Chair, Vice Chair, and committee members. Gary Suganuma, Director of Taxation. Currently, the payment under protest statute, which is HRS 40-35, requires or allows a suit to be filed after a final agency decision, and the suit must be initiated within 30 days of the payment of the amount in controversy. So that's the payment under protest. So what this measure seeks to do is to allow a prematurely filed action to be refiled within 2 years of the final agency decision that triggers the right to file the action. And as we noted in our testimony, the department is unaware of any valid reason why the time limit to bring an action to recover payment of taxes made under protest should be 2 years for a premature payment, but only 30 days for a properly made payment. And so our only request or our only comment is that we think it makes sense to align the deadlines so that someone who brings action prematurely and then refiles it should have to refile it within 30 days of the final agency decision. And we provided language in our testimony to effectuate that change in the bill. The last time this bill came up for hearing before House Finance, Mr. Yamachika from the Tax Foundation, I recall, testified that they didn't have any problem with the change that we're requesting, and maybe you can confirm that with him when he testifies. Okay. Thank you.
Thank you very much. Next up is the aforementioned Tom Yamachika for the Tax Foundation of Hawaii on Zoom. Good morning.
Yep, speak of the devil and I arrive, right? Good morning, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation. The reason that this bill has been introduced is because there's a kind of a question on how to do payment under process suits if it is found that they are filed prematurely. Right now, like Mr. Suganuma said, the requirement is that suit be filed within 30 days after payment. But the Supreme Court has engrafted a requirement that there be a final agency decision before that happens. And there may be some misunderstandings about what that is. So if it's held that the suit was premature, then there's a question of what happens, because obviously the agency won't give it back. And by the time it gets back down to the trial court, 30 days will have elapsed. So the question then becomes, okay, well, does then the agency keep it without any adjudication on the merits? We think that would be unfair. So that's why we had asked that the legislature consider a bill such as this one. As Director Suganuma said, we have no objections to the amendments that the department is suggesting. I'd be happy to answer any questions.
Thank you very much. That's everybody who signed up on HB 1805. Would anyone else like to testify on HB 1805, Zoom, in person? Seeing none, members' questions? I have a question for Director Suganuma, if you don't mind. A couple of questions, actually. I was confused by the nomenclature non-taxation case. What does that mean? I thought they were all taxation cases.
No, this is the payment under protest statute actually applies in any situation where there is a determination that someone owes the state money and they want to contest it, and so it would apply to fines for across all departments.
I got you. All right, I understand now. Okay. So then agency could be just about any agency of the state.
That's correct.
Okay. So if the agency doesn't decide in the 180 days and the money is refunded to the claimant, what happens if the agency rules against the claimant after the 180 days is over? That doesn't seem to be covered by the, so they,
No, I think in that situation, I think then the 30-day period would kick in, right? Because there would be a final agency decision whenever it's issued, even if it's issued 2 years later.
so, but
And
in terms of the money, the agency would have to give back the money, but then they win, and then they'd have to just collect the money again from
Then
the.
they would have to, the taxpayer would have to make the payment under protest at the appropriate time once this final
Okay,
decision is
but-
rendered, and they have 30 days.
But they would have the money, the tax, or the claimant would have the money in their hands when that occurred, as opposed to whoever the agency was at that point.
That's correct.
Okay, all right, that makes sense. Okay, thank you very much. Other questions, members? Okay, seeing none, let's go ahead and move on to the next bill. HB 1806, this removes language specifying that an appeal from the tax appeal court be filed with the tax appeal court. Normally you file with the Court of Appeals, I believe, and allows an appeal from the tax appeal court to be filed within 30 days of entry of a final judgment. First up on this one is Tom Yamachika for Tax Foundation. Morning again.
Good morning again, Chair, Vice Chair, members of the committee. Tom Yamachika for Tax Foundation. Yes, your observation initially is correct. Under modern practice, the notice of appeal is filed with the appellate court, not with the lower court. I mean, it used to be the other way around, but with the advent of the judiciary electronic filing system, they changed it up. In terms of the balance of the bill, what that does is there's some confusion now because there's a case called Alfred versus City and County of Honolulu that says you can appeal from basically a collateral order that the tax appeal court enters, even if it's not the final judgment. So some very experienced practitioners, including one former Supreme Court justice, appealed from the final judgment and was told by the Supreme Court of Hawaii that that's not okay. We are still waiting on a full opinion from the Supreme Court as to why that's not okay, but there is an order presently saying that it's not okay. So what the bill suggests is that it's okay to appeal from either the final judgment or the collateral order, and that would resolve the confusion regarding when jurisdiction to appeal happens.
Okay, thank you very much. Mr. Yamachika is the only one who signed up for HB 1806. Would anyone else like to testify in this measure? Okay, members' questions? I don't have any either. Let's go ahead and move on to the next bill. This is HB 1915 relating to Uniform Probate Code, updates the Uniform Probate Code by reducing the number of required publications of a notice to creditors by a trustee to once a week for 2 successive weeks, consistent with amendments made by Act 158, Session Laws of 2023. First up on HB 1915 is Jeanette Castagnetti, Chief Judge for Judiciary on Zoom. Oh, okay. Good morning.
Good morning, Chairman and rest of the committee. My name is Jeff Niebling. I'm appearing on behalf of Judge Castagnetti and the Judiciary's Committee on Uniform Probate Code and Probate Court Practices. We have submitted written testimony. This bill was originally designed to correct an error in the publication requirements that in the act that we just passed last session. We have received the comments by Carolyn Nickel, who is a former registrar of the probate court. We have a great amount of respect for her, and we've just recently read and discussed the proposals that she suggests in her testimony today. And we're willing to work with her to just iron out. There are some points that she raises that we agree with, and we would like to work with her some more to iron out some suggested proposed language. But I'm free to take any questions that you may have.
Okay, thank you. Next is Michael Tanoe for Commission to Promote Uniform Legislation. in support, and the aforementioned Carolyn Nicole in person. Good morning.
Good morning, Chair, Vice Chair, and committee members. My name is Carolyn Nickel. I'm a retired attorney and former probate court registrar testifying as an individual. I stand on my written testimony, but briefly would like to highlight 3 areas where Act 158 is deficient: time limits, original wills, and attorney's fees. Time limits. Act 158 replaced the troublesome paragraph A4 in HRS section 563-108, but made other changes in 3108 inconsistent with definitions and policies adopted by the Uniform Law Commissioners. Original wills. Act 158 amended HRS section 563-303 to allow the registrar to omit a copy of a will filed but not probated in another jurisdiction. But the Uniform Law Commissioner's comment on section 303 of the model UPC says, except where probate or its equivalent has occurred previously in another state, informal probate is available only where an original will exists and is available to be filed. Admission of a copy of a will not probated elsewhere should be decided by a judge, not the registrar. Attorney's fees. Please consider whether HRS section 563-720 is amended by Act 158 may result in improper windfalls to attorneys and clients to the detriment of a decedent's intended beneficiaries. My testimony last year described legislative history, uniform laws, and Hawaii case law germane to this topic. A draft proposed SD1 attached to my testimony includes language for your consideration to address these matters. Thank you for the opportunity to testify.
Thank you very much. That's everybody who signed up on HB 1915. Does anyone else wish to testify on HB 1915? Seeing none, members' questions?
Yes.
Senator Sin-Buenaventura.
Thank you. Carolyn Nickel. Thank you. Thank you so much for your very intensive testimony. I read it. My question is, the copy of the will
Yes.
in another jurisdiction. Your testimony is that it should be determined by the judge as to validity. How about an exemplified copy? Should it?
No, a copy of the will that's not probated in another jurisdiction. The
It-
registrar should be able to admit a probated will because you're relying,
Okay.
as comedy, relying on another court's decision that it was, but the rules
Yeah, I
nationwide
could
on
see that.
just depositing a will in court.
That's not
It's really
original.
not trustworthy. And
Yeah.
as a registrar, actually, I used to touch every original will. I'd look at it, I'd look at the folds of the paper,
Yeah.
I'd examine both sides of the signature to determine validity before it could informally be admitted to probate. And I wouldn't be able to do that with a copy. That's just my experience. So I was very wary about the opportunity for
Yes.
bad actors to take advantage of that.
Okay. Thank you.
Thank you. Other questions, members? Okay, seeing none, thank you very much. We'll go ahead and move on to the next bill, HB 2486, relating to tax enforcement. Authorizes Department of Taxation to serve administrative subpoenas outside the state. First up on 2486 is Director Suganuma for the Department of Taxation. Morning again.
Good morning. The department stands in strong support of this measure. This is, as you noted, an administration measure. This measure would allow the department to serve administrative subpoenas, both civil and criminal administrative subpoenas, outside of the state. So currently, the department is authorized to serve administrative subpoenas in civil audit, investigation, or hearing, or in a criminal investigation. However, the authorizing statute, which is HRS 231-7, states that the administrative subpoena may be served at any place within the state. The authorizing statute is silent as a service outside the state. With the growth of e-commerce, there are many taxpayers engaged in business in the state that may not physically be in the state or may not have an agent for purpose of service of to accept service of process within the state. And so what this would allow us to do is to at least be able to serve the subpoena as an attempt to find out information as to whether or not these taxpayers residing outside the state have conducted business in the state, and if they've conducted sufficient business such that we can, they're basically obligated to pay taxes to the state of Hawaii. And so that's all this does. We think it's fair. If someone is reaping the benefits of being able to conduct business in the state, then they should be, just like someone present in the state, subject to having to provide us with information so that we can determine their tax liability, if any, to the state of Hawaii.
Okay, thank you. Next up, we have Tom Yamachika for the Tax Foundation of Hawaii. Good morning again.
Good morning, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. We will stand in written comments and be available for questions.
Thank you very much. That's everybody who signed up on HB 2486. Would anyone else like to testify on HB 2486? Seeing none, members' questions? I don't have any questions either. Let's go ahead and move on to HB 2513. That's relating to expungement, expands expungement eligibility to persons whose convictions for consuming a measurable amount of alcohol while underage or first-time property offenses predated current expungement provisions. First up on 2513 is Haley Chang for the Office of Public Defender. Oh, you're here. Okay. Okay.
My name is Michelle.
Good morning.
Good morning, Chair, Vice Chair, members of the committee. My name is Michelle Moroka. I'm a Deputy Public Defender for the Office of the Public Defender. I've been a public defender now for 19 years, and I'm testifying in the capacity of my office as well as personally in support of this bill. This bill basically, it's very specific in nature, and it's just designed to, I guess, make the law, or make people who are convicted of these crimes in the past, bring them into parity with people who are facing these charges currently. I'd like to emphasize that this bill, it is limited to the offenses of individuals who are convicted of having a measurable amount of alcohol, which is not the same as a DUI. It's just any amount of alcohol. Minors who have who drank and drive with amounts over the limit, they could be additionally charged with a regular DUI. Which brings me to my point and support of this bill where, like I said, it brings it on parity to how the law stands currently, offering these individuals an opportunity to expunge these offenses from their criminal abstract. With respect to the minors' measurable amount of alcohol, I think in the current age, where people are struggling to make financial, decisions and employment is kind of hard to obtain, in the measurable amount of alcohol is kind of misleading in the fact that many employers would see that and think that it's a DUI, but it is not. It is strictly a status offense for people who are under the age of 21 who have a measurable amount detected in their blood alcohol level. And like I said, these are, nothing really changes. It just allows people who have been convicted of these offenses in the past to expunge their record, giving them more opportunities and being more productive members of society. Thank you.
Thank you very much. Next up is Pamela Ferguson Bray, Executive Director for Crime Victim Compensation Commission. In opposition. Next is Paul Mao for Honolulu Department of the Prosecuting Attorney. Good morning.
Good morning. Good morning, Chair Rhodes, Vice Chair Gabbard, and committee members. I'm Paul Mao. I'm the Chief of Staff for the Department of the Prosecuting Attorney. I'm here in strong opposition to HB 2513 HD1. Let me summarize the key points of the written testimony that we submitted from our department. Under Section 2, persons with a first-time DUI conviction applying for a commercial driver's license can circumvent protective restrictions by waiting until after receiving an expungement to apply. That undermines HRS 2086-240 and the federal driving record check. Under Section 3, there's a loophole that applies when multiple Class C felony property offenses are sentenced in a single hearing. An unlimited number of concurrent offenses would each consist a first-time offense, or constitute a first-time offense. We suggest amending 706-622.9 from a person convicted for the first time of any Class C felony property offense to a person convicted for the first time to a single Class C felony property offense. With regard to habitual property crimes under Section 708-803, they should be excluded from Section 3 since the basis of this property charge stems from a history of multiple prior offenses that have now escalated into a felony. Finally, with regard to expungement applications for a person sentenced prior to June 22, 2006, that shouldn't apply when the defendant commits further offenses after this first felony property conviction. It's inconsistent with the rationale that we've used for deferrals, which are premised on defendants who are not likely to commit a future offense. It would be absurd, really, to grant an expungement for anyone whose criminality did not end with the first offense. The bill must add language stating that an expungement is not available in these situations. Thank you very much for this opportunity to testify, and I'm available.
Thank you very much. Next is Alice Liu, Program Director for Mothers Against Drunk Driving Hawaii. In opposition, Sydney Story for Opportunity Youth Action Hawaii. In support, Tina Yamaki, President, Retail Merchants of Hawaii. In opposition, that's everybody that signed up for HB 2513. Would anyone else like to testify on HB 2513? Seeing none, members' questions?
Yes.
Senator
sorry.
Sanborn Ventura, go ahead.
Public defender. So I have a question similar to what the prosecutor is asking, has testified to. Basically, this bill allows for an expungement even though the offender did not get a deferral under 753, a DAG or a DANK. Is that, that's how I read this. Because otherwise they would be eligible for an expungement anyway.
The deferral, well, there may be many reasons for why an individual is not granted a deferral, and many reasons why maybe a deferral could be set aside. There's so many contexts that can be, applied under your question. But, there are situations where, this just deals with people who have maybe either not been initially granted a deferral or, my reading of it just pertains to a single offense. It can be limited to a single offense. It's just a one-time mistake. It's just putting it on parity and with how the statute reading for the first-time property offenses or drug offenses reads it as well. And I think because those statutes, and there's a multitude of requirements that go into it as well. They need to come up with a treatment plan as approved by the judiciary, and they have to come up with a way of funding for it. And then, at the end of the probationary term. So these are people who have completed a term of probation. It's not like you're rewarding them for something that hasn't happened, but they've demonstrated.
Okay. I understand the DUI because there is no deferment. And I understand certain offenses like FCCR, which isn't covered here, the abuse of family household member, where we later provided deferral status. But under deferred sentence, they are supposed to go under probation. They are already supposed to have all these conditions. So.
And in practice, that would be ideal, but not everybody, not all first-time offenders are granted a deferral for whatever reason.
Yeah.
Maybe they might have been going through a hard time in life. And again, this does nothing to, this just addresses the limited people who have, maybe completed probation, have restarted their life, just giving them the same opportunities as the people who have been sentenced under the new law are experiencing.
Okay.
So these are people who have worked hard to clear whatever they needed to clear, and who have demonstrated through the completion of probation, a treatment plan, and completing a rehabilitative program. Because that's part of what getting, I believe that a first-time property offender or first-time drug offender has to do in order to receive the expungement. So these are people who have gone through probation and the treatment and all the things that were required.
Okay, thank you.
Thank you, sir.
Thanks. Senator Elefante, go
Yes,
ahead.
is it Ms. Morioka? If you could come back to the table, please. Sorry, I have one question for you. Does the PDs keep a record of how many types of cases they would follow on a number that would qualify?
I'm sorry, are you talking just like all of the cases that would fall under this?
Yeah, or would potentially qualify for first-time property offenders or drug offenders in this case, you know, that would go for expungement?
You know, I don't believe that we have that type of statistics in our office. We do keep statistics, but with respect to like the specific type of crimes or, you know, like how many people actually move for expungement, I don't believe our office has an account of those specific statistics.
Okay, thank you.
But, you know, I mean, it is something that we would like to help out with more and to get people, you know, back into society as productive members.
Sure, thank you.
Other questions, members?
No.
Okay, I guess, if public defender and prosecutor wouldn't mind coming out together. Okay, so the question is, so, I mean, currently you already have an expungement possibility. Does that, is your reading, so my question for you guys is your reading, I'll start with the prosecutor, is your reading that it only applies to under 21s who have a measurable amount of alcohol, or do you think this applies, does the current expungement apply to both measurable amounts of alcohol and DUIs, or just measurable amounts of alcohol?
I thought it does apply to DUIs, actually. You know, if I look at
The current law.
Mhm. It's really, I thought it more envisioning whether the person was a first-time violator.
Okay,
I believe this bill is specific to the measurable amount of alcohol. It does not deal with
well,
a
it's really a
regular-
current law question, because this just adds
Yeah.
back people who didn't have this expungement opportunity before.
Exactly, so it just puts it on parity with current law.
Right, so that's why I'm curious about the current law. Is it just a measurable amount, or is it both measurable amount and a DUI?
Well, DUIs are not expungible, I believe. I don't,
I don't think so.
Okay, all right, well, some fact questions there. All right, thank you very much. Members, other questions? All right, thank you very much. Let's go ahead and move on to the next bill, which is HB 2570. This requires petitions or motions for Pro Hoc Vice appearance for a court or arbitration proceeding to be supported by certain evidence to ensure that both the applicant and local council will pay all state income tax due for Hawaii business activities, as well as any other information or documentation required by the rules of the Supreme Court. First up on 2570 is Thomas Berger, staff attorney for the judiciary.
Good morning, Chair, Vice Chair, members of the committee. The judiciary opposes this bill. The Supreme Court has published proposed rules that would ask the committee to defer the bill at this time.
Okay, thank you. Next up is Tom Yamachika for Tax Foundation of Hawaii. Hello again.
Oh, hello again, Chair.
That I put in my, with respect to affirmation about paying state income and general excise taxes. I'd appreciate it.
Sherry, how's it going?
All right, thank you very much. Next we have Bradley Tam in opposition. That's everybody who signed up on HB 2570. Does anyone else wish to testify on HB 2570? Seeing none, members' questions? Senator Elefante.
Yeah, I have a question for Marilyn, if she's still on Zoom.
Yes.
Hi. I don't know if you heard the judiciary's testimony that they're already going through rulemaking and comments are due at the end of the month. So being that they're going through that process, it would seem like it would not be necessary to have a proposed bill.
Well,
Would that be sufficient enough for you if they were to go through rulemaking and adopt rules?
it depends upon what the end result of the rules were, and that's where I had hesitation about whatever the rule was going to end up looking like. If it changed along the way because of other testimony, then I thought, well, maybe we should keep the bill going until we find out what the final rules were. But it involves not only the Chief Disciplinary Counsel enforcing this rule, but also the Hawaii State Tax Department would have to audit some of these attorneys who might have practiced in the past. So it's not for me to say, oh, I'm not enforcing anything. Our association is not enforcing everything, just bringing to the attention that this is not the only case where we have service providers coming to Hawaii and practicing, but there are other professions that are also providing services and not paying Hawaii taxes. I just want to make sure that Hawaii gets the proper amount of taxes that is owed, and that people in professions are paying the same amount of taxes, and everyone is playing in the same playing field.
Okay, understood. Thank you. Thank you, Chair.
Thank you. Other members, other questions?
Yes.
Senator San Buenaventura.
Judiciary? Alberta. So what are the requirements right now for getting approved as a pro hac vice attorney? Seems to me all it is just filing a motion to allow for someone to go for pro hac vice. Does the Supreme Court require any kind of investigation on the person who's going to be appearing before them?
I don't have the rule in front of me, so I'm just going from my memory. I do recall that you have to put a declaration that you've been affiliated with local counsel, but as the senator points out, it doesn't have the other requirements that you mentioned. So that's why the court has gone through its rulemaking process, and I believe it's March 25th or 24th where the comment period will end. And then at that point, the court can move forward with establishing the rules that this bill covers.
Okay, so I remember the comment period, but during the comment period, have you taken into account the legislator's request as epitomized in this bill that whoever is going to be accepted into pro hac vice pay their taxes?
Attached to our testimony is the exact language for the proposed rule amendment. So it tracks the bill. So I think the answer is yes.
Okay.
Thank you.
Thank you. Other questions, members? Okay, seeing none, let's go ahead and move on to the next bill, which is HB 2657. This establishes judicial procedures to prevent and remedy abusive litigation. First up on 2657 is Judge Jesse Hall for District Court, Family Court Judge for Judiciary. Good morning.
Good morning. Chair Rhodes, Vice Chair Gabbard, members of the committee. We've submitted our written testimony. I just wanted to point out a couple of the changes that we're requesting with regards to section 3, paragraphs 2H. The reason we're requesting that be removed is at the time there's a pending criminal charge, there is no order and no findings at that time. So we do have concern of due process with regards to that, as well as paragraph I, allowing an affidavit from a third party could violate the hearsay rules, also due process to the responding party, because they would not be able to question that person based on their affidavit. Finally, if a final effective date is placed into the bill, we are asking that we be given some time to allow for training as well as to amend our forms.
Okay, thank you. Next up, we have Ryan Kusamoto for President and CEO for Parents and Children Together. In support, next is Renee Hamilton Campbell, Executive Director for YWCA Hawaii, in support. Nicole Wu, Director of Research for Hawaii Children's Action Network, speaks.
Aloha, Chair, Vice Chair, members of the committee. Thank you for letting me testify quickly. Hawaii Children's Action Network cares about this bill because domestic violence survivors with children are especially susceptible to abusive litigation. This happens often during child custody cases when the former partners are parents together. Abusive litigation re-victimizes and re-traumatizes survivors and their children. So we hope Hawaii will join the other states that have enacted legislation to address abusive litigation. Thank you for letting me testify in support of this bill.
Thank you very much. Next is Ann Freed for Democratic Party of Hawaii's Women's Caucus. In support, Elizabeth Jubin Fujiwara for Hawaii Women's Lawyers. Also in support, Angelina Mercado, Executive Director for Hawaii State Coalition Against Domestic Violence. Come on up. Good morning.
Aloha, Chair, Vice Chair, committee members. I'm Angie Mercado, the Executive Director of the Hawaii State Coalition Against Domestic Violence. And we stand on our written testimony as submitted, and we're grateful that the committee is willing to hear this measure in the crossover. And we actually do have a suggested amendment to address the judiciary's concern raised in their testimony. And this specifically has to do with page 5, subsection H, the part that talks about the pending criminal charge. We do recognize that that is a due process issue, and the part of that section that we really care about is the latter half of it, which is as a result of which a court has imposed criminal conditions of release pertaining to the safety of the victim. So a suggested amendment is further up in this section, subsection F. Because in this state, for instance, our no contact order issued pursuant to section 709-906-4 of our statute addresses if in our state, if a judge is gonna, in the pending criminal case, issue a no contact order. So what we're thinking is, because we have to do full faith and credit of valid court orders, including protection orders from other jurisdictions, a suggested amendment, and we just came up with this, so I haven't submitted it in writing, is to add to section F, a no contact order issued pursuant to section 709-906-4 or other valid court order issued by any other jurisdiction. So then we're talking about where there has been some sort of a finding, and they are addressing the issue of safety, but we're not gonna, jeopardize any due processes because somebody is pending a criminal charge.
Okay. Thank you very much.
Thank you for listening. Thank you.
Next up is Hawaii Women's Coalition. In support. Next is Lindsay Dreher, also in support, and Rachel in support. That's everybody who signed up for HB 2657. Would anyone else like to testify in this measure? Seeing none, members, questions? Could I have Judge Hall back up, please? So you're suggesting inserting the words "and to the facts of that order" into the subsection having to do with the definition of abusive litigation?
Yes.
So what maybe I think you touched on it before, but can you just describe that, why that language is necessary?
So currently at the time of our TRO hearings, a respondent does have the ability to agree to an order for protection without the findings being made, in particular findings of abuse being made. So that is our concern, that we need to have this language in to address that situation where respondents are able to agree to stay away, agree to an order for protection without defining abuse. One of the benefits of having them agree to it is they don't have to the parties don't have to go through the hearing process. The victim doesn't have to relitigate the abuse that they went through. But also there are times that there may not be enough evidence to support an order for protection, but they're willing to agree to it right then and there. We're able to get many more order for protections issued at that point.
Okay. Okay, I think I understand. The judiciary suggests removing pending criminal charges and signed affidavits as grounds to determine that litigation is abusive. You did talk about that earlier. So the idea being that you just can't declare somebody an abusive litigator if there's no
finding.
Finding for it. Okay. All right. Okay. Thank you, members. Other questions? Okay. Thanks very much. That brings us to the end of our 9:45 agenda. If members are ready to vote, I'm ready to recommend. Okay. We'll go back to the top of the agenda. HB 1805, relating to procedure for payment under protest lawsuits, allows for the interest earned on payments under protest and the litigated claims fund to be paid in non-taxation cases if the claimant prevails, and does some other things as well. On HB 1805, recommendation is to accept DOTAX's amendment to change the refiling date from 2 years to 30 days if the claimant needs to refile after an adverse agency decision to make it consistent with what would happen for a claimant who made their payment at the correct time. Or maybe it's the other way around. So for somebody who made it prematurely, it would make it the same. Anyway, make the same, and we'll make it effective upon approval. Questions or concerns? If not, Senator Gabbard for the vote.
Chair's recommendation on HB 1805 is to pass with amendments. Chair Rhodes.
Aye.
Vice Chair Rhodes. Aye. Senator Elefante.
Aye.
Senator San Buenaventura.
Aye.
And Senator Awa is excused. Measure passes.
Thank you. Next up is HB 1806. This removes language specifying that an appeal from the tax appeals court be filed with the tax appeal court, allows an appeal from the tax appeal court to be filed within 30 days of entry of a final judgment. Recommendation is to amend it just to make it effective upon approval. Questions or concerns? If not, Senator Gabbard.
On HB 1806, recommendations to pass with amendments of the members present. Are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 1915, relating to the Uniform Probate Code. Updates the UPC by reducing the number of required publications of a notice to creditors by a trustee to once a week for 2 weeks, to make it consistent with a previous law. Haven't quite had time to digest all the proposed amendments, so I'm going to defer this until, let's see, this is the one that was re-referred to JDC. So I'm going to defer this to Thursday, March 21 at 10 a.m. in this room 016. Next up is HB 2486, authorizing the Department of Taxation to serve administrative subpoenas out of state. Recommendation here is to pass with technical amendments and make it effective upon approval. Questions or concerns? If not, Senator Gabbard.
Recommendation is to pass with amendments. The members present, are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 2513, expands expungement eligibility to persons whose convictions for consuming a measurable amount of alcohol while underage or first-time property offenses predated current expungement provisions. The recommendation here is to go ahead and clarify in the preamble that the drunk driving under the influence offense applies to persons under the age of 21 and make it effective upon approval. A very narrow bill. Questions or concerns? If not, Senator Gabbard.
Recommendations to pass with amendments. Are there any no votes or reservations? Measure passes.
Thank you very much. Next up is HB 2570, requires petitions or motions for pro hoc vice appearances to do certain things. Having recognized the judiciary's efforts in this regard, I'm just going to suggest that we put a different defective date on it and let the bill go forward for the time being. So the new defective date would be April 14, 2112. Questions or concerns? If not, Senator Gabbard.
Recommendation on HB 2570 is to pass with amendment. Any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 2657, related to abusive litigation. On this one, I haven't had time to digest everything that's the testifiers are presented, so let's defer this until Thursday, March 21 at 10 a.m. Okay, we do have a 10 o'clock agenda now that it's 10:30, but I'm going to take, let's take about a 4-minute recess and we'll start up at, sorry, let's get a clock that's actually right. Let's take a 5-minute recess and start up at 10:37. Adjourn for the first adjourn for the first agenda. Okay, moving to the 10 o'clock agenda. If we have a catastrophic failure on the Zoom side, we'll try again on March 19 at 9:31 a.m. in this room 116. I believe that's Tuesday. First up on the 10 o'clock agenda is HB 1916 relating to disclosure of personal information associated with certain public servants. First up on 1916 is Thomas Berger, staff attorney for the judiciary.
Good morning, Chair.
Good morning,
Chair,
again.
members of the committee. I'm Thomas Berger, I'm a staff attorney. The judiciary is in strong support of this bill, and thank you to the committee and the committee staff for moving the bill forward. Our written testimony had some suggested amendments. These amendments would really clarify that this bill has nothing to do with the Uniform Information Practices Act. The intent of the bill is to simply remove the government record from the internet, but the record would still be available in person, which is the way it is now, right? And then the second aspect of our suggested amendments would be to add an express provision to protect the First Amendment rights of the public and the press. So, there's a clear need for this legislation, and we appreciate the committee's work to move the bill forward.
Thank you. Next up is Chairperson Chang for the Department of Land and Natural Resources. Or her designee. Good morning.
Designee. Aloha, Chair, Vice Chair. Les Kobata, I'm the Registrar of the Bureau of Conveyance on behalf of Don Chang at DLNR. We've submitted comments and just some relatively strong concerns regarding implementation of this program. We fully recognize the importance of being able to support something like this. We currently, though, don't have a convenient or a set method of being able to do that. It would require system upgrades. It would require additional staffing to do this and funding. So some of those, and of course the timing of how soon it's expected to be implemented. So those are some of our concerns, and I'm available for the questions you might have.
Great, thank you.
Okay, thank you.
Next up is Laura Mayashiro for Department of Law Enforcement. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, and members of the committee. My name is Laura Mayashiro. I'm with the Department of Law Enforcement. The Department of Law Enforcement fully supports the protective provisions in this bill. It's only the placement of it. It is being placed in, or one part of it is being placed in Chapter 801G. That is the address confidentiality program. It is a completely separate standalone program where survivors of domestic violence need to actually apply, and the Department of Law Enforcement is tasked to implement the program by statute. This scheme that's put in here is, again, its own standalone protection for these public servants. So it really doesn't belong in there. The intent appears to be part of the address confidentiality program, if you look at the bill's description. So with that, there's no real nexus between the two. So all it would do is cause confusion. A suggestion would be to just simply place this into another subsection of 801H, if that's not being used. I don't believe it is, but something to that effect, rather than incorporate it as part of the address confidentiality program, because it really is two separate programs.
Okay.
And thank you very much for allowing me to provide comments.
Thank you. I should have mentioned it at the top, but we did post a proposed SD1, and I believe that most of the comments that have been made are about that, just for everyone's knowledge. Next is Mark Tom, Deputy Attorney General. Good morning.
Good morning, Chair, Vice Chair, members of the committee. Deputy Attorney General Mark Tom for the department. Department just provides comments and with some suggested amendments for House Bill 1916, proposed Senate Draft 1. Specifically, in its current form, the offense that's created in this bill, unlawful publication of personal information, it just appears that it's unenforceable in its current form. So The suggested amendments that we provided was providing additional definitions, and specifically in Chapter 711 where this proposed new offense would be housed. I put some of the terms that need to be defined or should be defined to make this a little more enforceable. Second portion is removing some of the vague and ambiguous terms such as reputational harm, emotional injury, maybe using some language of harass, annoy, or alarm, which is found in 711, 1106 in the harassment statute. It will be allow this new offense to be a little more enforceable and to be prosecuted. Last is removing the enhanced Class C felony. Just the way that it's currently written, it appears that it might be very unenforceable based on the terms. Currently, there are statutes in our HRS that might cover what this Class C enhanced penalty would try to address, such as TT1, terroristic threatening in the first degree, when it involves a public servant or a public official. That's already covered as a Class C. Although it can't be covered in this bill based on the title, one thing to look at if the committee does want to still address assault type injuries, placing it as a protected class in assault in the second degree in 707, 711, and just creating a protected class that this committee is trying to protect in regards to assault when it involves unlawful publication of personal information. We'll be here for any questions. Thank you.
Thank you. And the normal course of business is for us to, well, anyway, I'm going to skip ahead on the testifiers to Judge Clifton from the Ninth Circuit Court of Appeals. Good morning. Thanks for your patience.
Good morning. Thank you for taking up the matter. Chair, Vice Chair, members of the committee. Been identified. I'm Richard Clifton. I'm a judge in the Ninth Circuit Court of Appeals. I've been a member of the Hawaii Bar for over 40 years. I want to count much higher than that. And a member of the Ninth Circuit for the last 20 some years. I should make clear at the very beginning that judges, federal judges and state judges are all subject to codes of conduct. They're somewhat different, but federal judges don't participate in politics and don't customarily participate in the legislative process. There is an important exception for matters affecting the justice system. And that's what brings me here. I want to make it clear I am not seeking to comment and cannot comment on the application of this bill to people outside the judiciary. And I'm not in a position to comment on, I'll call the mechanics or the specifics. It's my job and my colleagues' job to frequently interpret and apply statutes. We're not supposed to formulate them. And so I want to be clear about that limitation. Having said that, I urge the committee to keep our eyes on the ball here. Judges are at risk. Nobody's disputing that. My concern is that the history demonstrates that the greatest risk is at home. Judge Salas, Judge Lefkoe, the federal judges who I specifically discuss in the testimony because those events are public. Judge Browning's testimony reveals what has not been entirely publicized, happened to him at home here. There are federal judges in Hawaii who it has been publicly revealed have received serious threats. Frankly, I suspect I have, all of us have, we just don't talk about it. We don't want to encourage people to think in those terms, but it's a serious problem. And so I much appreciate this legislation.
I apologize, Judge. I've managed to keep my 2-minute rule intact for about 14 years, and so members may have questions for you.
I understand. Please keep our eye on the ball and do something about the problem.
Thank you very much. Also, I see Chief Justice Rechtenwald. I know your name's not on the testifier list, but did you want to testify on this? I'm not requiring it or anything, but it's up to you. Okay, thank you. Good morning.
Very brief. I'll keep it under 1 minute. I just wanted Chair Rhodes, Vice Chair Gabbard, members of the committee. I just echo Judge Clifton's remarks, and because of my position as Chief Justice, I'm aware of pretty much all of the threats that we get, at least those that are more serious. There's been a dramatic spike particularly in the last 3 years, both in the number of threats and in the intensity of those threats. We have a pending terroristic threatening case on Maui involving one of our judges. We've had many instances of judges having folks come to their homes purportedly to serve process. We've had instances where calls that are being made include information about the judge's address, which I think is a sort of a back doorway of letting the judge know that I know where you live. And fundamental to our system of justice is being able to have a system where folks come to court and can feel safe and do the job they have to do, free from any external threat or risk of harm, and especially to their families. And again, this type of really the linchpin here is the availability of this information on the internet. And what our amendments do, and I think echo what the committee has done, and I thank the committee for all of its work, and I thank you, Chair Rhodes, for being such a leader on this issue, is to make clear we're talking about posting on the internet. We're not talking about sealing paper records that might exist in the records of various government agencies. We're talking about making it harder for folks to be able to go online, perhaps when they're angry, perhaps when they're particularly unstable at a particular moment, being able to get an address and then go act on an impulse to harm a particular judge or their family. So I think the committee's very much on the right track with the SD1. We have a few edits that we've suggested, and I really appreciate the committee's consideration.
Thank you very much.
Thank you.
Thanks for coming down. Next, we have Cheryl Kakazu Park, Director, Office of Information Practices, on Zoom. Maybe.
Good morning, Chair, Vice Chair, and committee members. This is Jennifer Brooks here for OIP on Cheryl Kakazu Park's behalf. OIP is going to stand on its testimony with concerns and a proposed amendment, but I am very happy to answer any questions the committee might have. Thank you.
Thank you very much. Next is Andrew Kawano, Director for the City and County of Honolulu, with comments. Next is Ben Krebs, Staff Attorney for Public First Law Center.
Right.
Good morning.
Chair, Vice Chair, members of the committee, Ben Krebs for the Public First Law Center. You have a written testimony with comments on the HD1 and opposition to the SD1, proposed SD1, excuse me. And we know this is a very important issue, but given the novelty and the potential reach, we respectfully suggest a more limited initial implementation, a pilot project of sorts, and that's why we generally prefer the HD1 as a vehicle. It's more targeted and limited in its definition of covered person. It is narrow, it has a narrower definition of protected information, and it also has no criminal provision. And then with the lessons learned, the legislature can expand the law in future sessions in a measured and informed way. Looking at the proposed SD1, I'd like to draw the committee's attention to the fact, and I think this was brought up by the AGs, that the criminal provision does not include any definitions. There are definitions in the civil provision, but that's obviously in a different chapter. If the proposed SD1 is the chosen vehicle, please give serious thought to dropping the emotional injury or reputational harm as intent requirements, and I think that's been proposed by the judiciary. I did have a chance to review the judiciary's proposed amendments, and generally we are supportive of those. I think those were amendments to the HD1 and not the proposed SD1. Last, if a criminal provision is included, please also consider adding a newsworthiness exemption, and I believe that's been proposed by the judiciary. Happy to answer any questions.
Okay, thank you. Next, we have Mihoko Ito for Consumer Data Industry Association on Zoom. Oh no, you're here. Yeah. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, members of the committee. Mihoko Ito on behalf of the Consumer Data Industry Association. We certainly support the intent of this measure and don't have concerns with what it's intended to do, but unfortunately, with respect to the proposed SD1, there are some concerns regarding the language related to the disclosure, section 3, page 5. Unfortunately, for the Consumer Data Industry Association, and that is like consumer reporting agencies, we do think that in the way that's drafted, it's going to harm the very people it's intended to protect, because it impacts the data, it impacts everyday transactions like credit, identity verification, and that sort of thing. And so we are concerned, we support the House bill because it doesn't have that specific disclosure language and is based on intent to harm and knowingly making data available publicly on the internet. So anyway, we're happy to propose language, but it's basically, we believe that the House bill is in line with most other states. The one state that did it the way the proposed SD1 did it resulted in, there's actually over 200 lawsuits that are pending that are, that the Consumer Data Industry Association believes are frivolous and is now defending because it implicates consumer reporting agencies. Happy to answer any questions.
Okay.
Thank you.
Thank you very much. Next is Jesse Suki, Hawaii State Bar Association President. In support, Dylan Hoffman, Executive Director for TechNet. In support, American Judicature Society. In support, you're here. Okay. Good morning, Mr. Louis Kwan.
Good morning. Hello, Chair Rhodes, Vice Chair McGadward, and members of the committee. My name is Ivan Louis Kwan. I am a member of the American Judicature Society's Ad Hoc Committee on Judicial Security. We stand in strong support of this measure, and we also are very supportive of the judiciary's proposed amendments. What we'd like to do is say a few things. One is to thank you, Chair Rhodes, and members of the committee for your very hard work on this, because this is, from our perspective, very important. This protection of judges really has a strong nexus to the rule of law, the delivery of justice, and ultimately to the quality of life for the people of Hawaii. So we thank you for this, and we urge you to continue to drive this home. Thank you so much.
Thank you. Next is Philip Recht, partner for Spokeo People Finders, Bin Verified, Truth Finder, Instant Checkmate, Classmates, and Tellius. In support, Kirsten Hammond for Hawaii State Trial Judges Association. Also in support, Sterling Morita, Hawaii Chapter Society of Professional Journalists. In opposition, London Biggs, Director of Government, State Government Affairs for Relics, LexisNexis, I believe, with comments. Retired Judge Ronnie Barra in support. Retired Judge Margaret Masunaga in support. Retired Judge Robert Browning in support. Retired Judge Joseph Cardoza also in support. That's all the testimony. It's everybody who signed up to testify in HB 1916. Does anyone else wish to testify in HB 1916? Come on. Morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, and members of the committee. I'm Daniel Hugo, representing the Department of the Prosecuting Attorney for the City and County of Honolulu. We do have some concerns about HB 1916 SD1. I'm confining my remarks to the proposed offense of unlawful publication of personal information. The first concern that we have, while we certainly support the intent to protect public officials, the first concern that we have is that some of this conduct can currently be prosecuted as terroristic threatening in the first degree, which is a Class C felony. If this offense were found to be a subspecies of terroristic threatening in the first degree, by operation of the Modica rule, we would be obligated to, or we could only obtain a misdemeanor conviction for the same conduct. The second problem is that as it's currently drafted, this statute could be found, this offense could be found to be overly broad with respect to the First Amendment, and that would allow a facial challenge even to someone to whom it could lawfully apply, which would be a serious problem for enforcement. So those are the two concerns that we have, but we certainly support the intent to protect public officials from criminal threats and harassment. Thank you.
Thank you very much. Anyone else wish to testify in HB 1916? 1960 on Zoom. Okay, seeing none. Members' questions? Okay, I don't have any questions at the moment either, so let's go ahead and move on to the last bill. It's HB 2072. This has to do with related campaign finance, requires certain solicitations that reference disasters to include a disclosure. First up on 2072 is Gary Cam for Campaign Spending Commission. Thanks for your patience. Good morning.
Good morning. Good morning, Chair, Vice Chair, members of the committee. The Commission supports this bill. Our Commission's brief comments are probably not helpful to the Commission, but the HD1 did address the concerns that we raised before the House Judiciary Committee.
Okay, thank you. Next is William Bento, Office of Public Defender. In opposition, that's everybody who signed up on HB 2072. Would anyone else like to testify on HB 2072? Okay, seeing none, members' questions? Okay, in that case, let's go ahead and vote. On the first one, HB 1916, we've got a lot of testimony. I'm sorry, HB 1916 is relating to disclosure of personal information associated with certain public officials. Gotten a lot of information in the last 48 hours here, and we haven't digested it all yet, so I'm going to defer this one for a week, less than a week, to March 21, which is Thursday at 10 a.m. in this room 016, so deferred until next Thursday, this coming Thursday. Okay, on the second one, HB 2072 requires certain solicitations that reference disasters to include a disclosure, deems violators guilty of a Class C felony. Our recommendation here is to go ahead and amend it by making it effective upon approval. Questions or concerns? If not, Senator Gabbard for the vote.
Chair's recommendations to pass HB 2072 amendment. The members present, are there any no votes or reservations? Hearing none, the measure passes.
Thank you very much. That concludes our business for the day. Have a good weekend. We're adjourned.